Advantage 1 is primary care. It's classing in the U.S. because the payment system focuses on volumes, no quality. That causes doctor burnout and overruns on prescriptions and specialists, which cause skyrocketing costs that ship. In time, there's no primary care costs in the U.S. fraction less outside.
To write an AFF is to write a story. Like any good story, a good AFF develops themes, introduces its setting, fleshes out its cast of characters, and has a plot with a beginning, middle, and end. A good story draws the judge in, enticing them to fill in the gaps you leave and ignore those pointed out by your opponent. Like writing a story, writing an AFF is both an art and a science. It's research and planning mixed with a series of hunches, intuitions, and judgment calls. There's a place for rules, and there's a place for risks. My name is Anthony Trufanov. In this series, my goal is to walk you through my AFF writing process, what I think about, how I stay organized, how I research, and what my workflow is, by giving you a tour through the file I produced for the Georgetown-Dartmouth Debate Institute Starter Pack. But before we get into it, let's talk about the AFF I ended up writing.
It's everything that a lot of people thought it would be, except far worse.
Serious abuse by the Obama administration.
A scorched earth, no-holds-barred war of resistance.
A few very long months ago, you might remember hearing something about FISA on the news.
Doing their utmost to destroy the underpinnings and the foundations of our democracy.
The controversy concerns an obscure spying law called the Foreign Intelligence Surveillance Act.
It's a way to get full surveillance on somebody without having to go through the normal requirements that apply for a normal Fourth Amendment warrant.
Under this law, federal spying and law enforcement agencies, like the FBI or NSA, are prohibited from spying on Americans unless they go to a special court, the Foreign Intelligence Surveillance Court, or FISC, and prove that those Americans are working for foreign powers.
The main difference is that's only supposed to be used when the government is trying to surveil a foreign spy or a terrorist or some other similar threat to the national security. It goes through this whole process and involves classified information and a secret judge and a secret court.
This law has seen tons of controversy over the course of its lifetime. Back in 2013, a whistleblower named Edward Snowden leaked classified documents proving that the Foreign Intelligence Court had authorized the NSA to spy on millions of Americans' phone and internet communications. The disclosures posed a grave challenge to the intelligence community's credibility and trustworthiness, but they were nothing compared to what was to come in 2020.
They fabricated evidence and they lied to the courts.
We identified significant inaccuracies and omissions in each of the 4 applications, 7 in the first application and a total of 17 by the final renewal application.
For years, Trump claimed that the FBI was trying to undermine his administration by fabricating evidence and opening politically damaging investigations into his campaign. It turned out that he was right, but only partly.
There's really enough here in it for both sides to claim they were right. Republicans say this report exposes wrongdoing by the FBI, and Democrats say it proves the investigation was legitimate.
According to 2 reports by the Department of Justice Inspector General, the FBI did in fact open investigations into a Trump campaign staffer, Carter Page, based on some poorly vetted sources. They got approval from the Foreign Intelligence Court, but they did so by withholding key information that would have cast doubt on their evidence. Even worse, the FBI systematically misled the court when asking for surveillance, frequently providing incomplete or undervetted information.
The good news is we have less reason to worry that the FBI had been engaged in anything politically motivated when they screwed up with Carter Page. The bad news is it looks like a widespread problem of shoddy process.
The problem is that the Foreign Intelligence Court is not like an ordinary court. Unlike most criminal courts, where the accused have a right to know the evidence against them, potential surveillance targets are not even told that they're being investigated. Instead, surveillance requests are evaluated ex parte, which means only one side, the government, is represented. When the government is honest, this arrangement works well. Unfortunately, the government is not always honest.
I am skeptical historically about the extent to which we should trust the process, right? And the extent to which internal government checks are, if not presumptively adequate, at least entitled to some general assumption of relative adequacy.
That's Stephen Vladeck, law professor at the University of Texas. Vladeck says that the problem with the foreign intelligence process is its lack of adversarialness, which is a fancy way of saying that no one is there to contest the government's assertions.
My concern for about as long as I've been familiar with FISA is that it's not about good faith versus bad faith. It's about the lack of adversarialness. Even officers who have no malice might cut corners, might not dot the I's and cross the T's in circumstances where literally no one is going to call them out on it.
The controversy could not have come at a worse time for the intelligence community.
We have a bit of a forcing function in that we have other unrelated FISA provisions that have got to be dealt with. The roving wiretaps, lone wolf, and 215 renewals that got kicked over from December. Now, that shouldn't require touching Title I, but the name FISA will be in the air, and I can easily imagine that there ends up being some momentum to do something.
Chesney turned out to be right. Those authorities expired in March and still haven't been reauthorized.
And the president made it absolutely clear, no quibbling about it, absolutely clear, he will not sign a clean reauthorization of the Patriot Act unless we reform FISA.
So, where do we go from here?
Stunning, damning, show a system off the rails.
My amendment with Senator Leahy would make reforms to applications for surveillance.
The proposal I gave him was this: don't use FISA, which is a foreign intelligence court, to spy on Americans.
The resurgence of the FISA controversy has spurred dozens of proposals, ranging from internal FBI audits to simply firing the responsible agents to tearing down the foreign intelligence apparatus altogether. The danger of such proposals is that many of them risk disrupting the legitimate work of intelligence agencies in protecting the United States from foreign threats.
We're going to overreact to what happened with Trump and narrow FISA surveillance so much that it puts us back into the box we were in before 9/11, where the government were afraid to use FISA properly, and that's one of the few things that would have stopped the 9/11 attack.
The challenge is to create a system that filters out inaccurate information while retaining the speed and flexibility that the intelligence community needs to stay effective.
National security law is a field of law where ex-ante tools are much harder to defend normatively than ex-post tools, because in this context, what would ex-ante tools look like? You're not going to put a lawyer in the FISA court to argue against the government's FISA application. I think the right way to do this is a series of after-the-fact checking and auditing mechanisms that exert hydraulic pressure on the process to be cleaner on the front end.
It is here that criminal justice reform can play a vital role. By subjecting FBI evidence produced from FISA to adversarial testing in criminal courts, criminal justice reforms can force FBI investigators to be more cautious on the off chance that surveillance gives rise to a criminal case and ultimately gets challenged.
One of the other ways to put pressure on the government to really have its ducks in a row when it's pursuing a FISA application is to put more teeth into the defendant's right to collaterally attack the application if and when the government's going to use evidence against them in a criminal trial. It's a tiny fraction of FISA cases that ever end up in that context, but the hydraulic pressure of having that out there and of the government knowing that this application could one day be meaningfully scrutinized by an Article III non-FISA court judge in the context of a motion to suppress. I have to think that would have a salutary effect on the rigor and the procedural propriety of what the government does.